presents some evidence that would suggest you probably committed these offenses, or not these offenses, these violations.
Yeah.
You then have a right to have a final hearing on the merits. And that would be another day and time if that's what you wanted, to give you time to prepare and talk with your lawyer. And that would be a hearing where the state would have to prove the actual merits of what they're alleging. Now, you have the right to have either or both of these hearings, but you could also waive the hearings if you desire and plead guilty to the violations. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes.
Well, before I can accept your waiver of the hearings and your plea of guilty, I need to make sure you understand the potential consequences you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it could be anywhere between 6 to 12 months on each case. That could be consecutive, so possibly 2 years in prison. Do you understand the potential penalties you face if you are found to have violated your community control sanctions?
Yes, sir.
Well, having been so advised, what do you want to do at this time? Do you want to have either of these hearings, or do you want to waive both hearings and plead guilty to the violations?
I'm gonna waive it and plead guilty.
Very well, then as to that Rule 3 violation for failing to report to your probation officer since January of 2022, what is your plea to that?
Guilty.
As to the Rule 11 violation for not completing the program at New Beginnings, what is your plea to that?
Your Honor, I completed.
Well, all right, not following the recommendations for the aftercare recommendations.
I was the one who recommended that I was gonna go to a sober house from there. That was me, on my own.
Just the aftercare, though, that was recommended.
Oh,
So you're
is
not-
that like probation?
And you're not pleading guilty to this violation?
I wanna get it done and over with today, yes.
And the Rule 8 violation for using heroin, what is your plea to that?
Guilty.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions. Mr. O'Connor, any reason not to go forward with sentencing?
Your Honor, we're prepared to go forward with sentencing today.
Anything you'd like to say on behalf of your client at this time?
Thank you, Your Honor. Your Honor, both myself and Mary Springer had spoken with Ms. Fields prior to this hearing today. Ms. Fields has expressed to both of us that she does not wish to waste the court's time, and which is why she wished to waive her hearings, admit guilty to the violations. She recognizes that she messed up an opportunity the court had provided for her. We would ask consideration for the credit that she does have, as well as the time that she did spend in treatment. We understand that ultimately, January, that she did not follow the aftercare recommendations, but she did, from end of October into January, follow through with their program. But she recognizes that she has broken the court's trust as well as probation's trust by being gone for the past 2 years, and she's not going to try to shy away about that. So we would ask that community control be terminated, that some time be imposed, but we would just ask consideration due to the fact that, one, she did complete most of the inpatient portion, but also consideration of the fact that she's owning up to it and not trying to waste this court's time.
Thank you. Ms. Fields, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
No, Your Honor, I've struggled with drugs for a long time, and I'm sorry that I'm just here again. I feel just, it's just annoying. I don't know why I can't just, overcome this. I don't know. I just want to be done with this.
Thank you. Well, this court has reviewed the pre-sentence report investigation that was completed in this manner, along with the drug and alcohol evaluation. I've considered the facts and circumstances of the offenses involved, the nature of the offenses involved. I have considered what's been said here in court, as well as the defendant's performance on probation. All of this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911 of the revised code. As for the factors in 29-2912, I'll incorporate all the findings I made at the original sentencing hearing regarding the seriousness factors and the recidivism factors, with the additional finding. At this time, the defendant has failed to comply with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. At this time, the court finds the defendant, particularly that she's been gone for almost 2 years, she's not amenable to available community control sanctions. Prison is consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that in case 21 CR 910, the defendant serve a term in prison of 12 months. In case 21 CR 913, that she serve a term in prison of 12 months. I'll run those cases concurrent with each other. She has credit in case 21 CR 913 for 106 days, and she has credit for 116 days in 21 CR 910. Need to advise you, Ms. Field, upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Defendant's ordered to pay all costs, and the court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Mr. O'Connor, anything else at this time for the record?
Nothing further, Your
All
Honor.
right, thank you. President, case 19 CR 751, State of Ohio versus Robert Herbatin. We are present for a final hearing on a motion to terminate the defendant's community control sanctions filed by the State of Ohio. Defendant is here in court. He's with his attorney, Mr. Daniel O'Connor. Mr. O'Connor, what's the defendant's plan at this time?
Your Honor, I spoke with Mr. Vincent earlier today in regards to his right to a final hearing on the matter, and he's prepared to waive that right. He understands that the maximum penalty here he's facing is 18 months minus the credit he has, but he's prepared to waive that hearing and admit to the violations.
Thank you. Herbatin, you've been charged with violating the conditions of your community control sanctions. Specifically, there are a total of 4 violations. First allegation is that Rule 3 violation, which requires you to report at such times and places as directed by your probation officer. It's alleged that you failed to appear for probation appointments on March 21st, March 23rd, March 28th of 23, and you haven't been around since then. So that's the Rule 3 violation. There was then an addendum filed alleging 3 more violations. The first is a Rule 1 violation, which requires you to obey all local, state, and federal laws, and it's alleged on October 26, 2023, you were arrested and charged with aggravated possession of drugs, a felony of the 5th degree, and falsification of misdemeanor of the 1st degree, and those matters have been resolved in Mentor Municipal Court as misdemeanor offenses. So you were convicted of, I don't know if it was 1 or 2 misdemeanors in Mentor Municipal Court. Do you know?
Two, sir.
Two misdemeanors in Mentor Municipal Court. The next violation is a Rule 8 violation, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. And it's alleged that you used cocaine and admitted to using cocaine on October 30th of this year. The last is the Rule 11 violation, which requires you to comply with all special conditions set forth by this court. And there was an order that you were not to have any contact with Whitney Culotta, except to call your daughter. And when you were arrested on October 26th, you were actually with Whitney Culotta at the time. Now, you have the right to have a final hearing regarding these 4 violations. A final hearing is a hearing where the state would be required to prove the actual merits of what they're alleging. Now, you could have this hearing, but you can also waive the hearing if you desire and plead guilty to the violation. Your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, sir.
Before I can accept your waiver of the hearing and your plea of guilty to the violations, I need to make sure you understand the potential consequences you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I sent you to prison, it could be anywhere from 6 to 18 months. Do you understand the potential consequences you face if you are found to have violated your community control sanctions?
Yes, sir.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and plead guilty to the violations?
Waive the hearing and plead guilty to the violations.
Very well. As to the Rule 3 violation for failing to report to your probation officer since March of this year, what is your plea to that?
Guilty.
As to the Rule 1 violation for having been convicted and committed and convicted of a new offense, criminal offense while on probation, what is your plea to that?
Guilty.
As to the Rule 8 violation for using cocaine while on probation, what is your plea to that?
Guilty.
And as to the Rule 11 violation for violating the no contact order by having contact with Whitney Culotta, what is your plea to that?
Guilty.
All right, the court will accept your plea of guilty to the 4 violations, find that you did, in fact, violate the conditions of your community control sanctions. Mr. O'Connor, any reason not to go forward with sentencing?
Your Honor, we're prepared to go forward today.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. Your Honor, in discussing the matter with Robert, he understands that he is messed up in regards to probation and appreciates the chances that this court has given him in the past in regards to treatment. While he is still working to address his addiction issues, he knows he's got a lot more work to do. We'd be asking the court to terminate his community control at this time. We would ask, I believe he has approximately 10 months of credit. We'd be asking for an additional 3 months, so for a total of 13 months to be imposed with credit for 301 days of credit. He understands there has to be consequences for his actions, and he's prepared to take responsibility whatever happens today. His plan to long-term, which I know he'll go into a little more detail, he's dealt with some health issues over this past year and recognizes that he needs to get sober, otherwise it's only going to worsen his health issues. He had a heart attack in the past year, and so his hope is to get enrolled once he's done his time and had his consequences in regards to this matter, to enroll with Lake House so that, one, he can benefit from the treatment program again, but two, so that he's able to use their resources to find sober living, find stability, and develop a new support system so that he's able to stay out of this court or any other court's system. And so that is his ultimate goal, and because of that, we would ask that the court take into consideration that he's accepting responsibility for his actions, and we would say that this is no more serious or less serious than a similar like case as far as when it comes to aggravated possession. But as I said, he has some words of his own, and I will leave it to him from there.
Thank you. Mr. Ravat, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you'd like to say at this time?
Yeah, I just want to apologize, and like I said, I appreciate all the chances I've gotten. And I don't know why I gave up this time. I mean, I wasn't feeling right. I did have a heart attack. It's not an excuse. It's just, I wasn't feeling right. It just made me maybe not care at that time, and I should have. And I just want to apologize and appreciate all the chances I've already received. So I'm willing to accept the consequences. And that is my ultimate goal, go back to the Lake House, because they did help me the first time with the resources I needed. You know, that's what helped me the most. So, I mean, no matter what happens here, I'm definitely going to go back when I'm done, you know, serving my sentence here. So I just want to say thanks for all the opportunities.
Thank you. Mr. O'Connor, anything else?
Nothing further, Your Honor.
Court reviewed the pre-sentence report and investigation. That was completed in this manner. Considered the facts and circumstances of the offense involved, the nature of the offense. I've considered what's been said here today by the defendant and his attorney. And I've also considered the defendant's overall performance on probation since this case first started. This is all considered by the court and are the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, I will incorporate all the findings I've made throughout this case regarding the seriousness factors and the recidivism factors, with the additional finding today that the defendant has not just failed to comply with previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely, but actually one of the violations is for committing a new crime, which showed that recidivism actually occurred. At this point, it's clear the defendant won't follow the conditions of this court. This is his third probation violation that he's had. He's still violating the conditions. You're still having contact with Whitney Culotta on a daily basis almost, even though you're not supposed to. He's not going to follow the rules. He's going to do what he wants to do. So he's not amenable to available community control sanctions. Prison is consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that on count 4, the defendant served a term in prison of 16 months. He has credit for 301 days on this case. I need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another In this case, 8 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence here today. Defendant's ordered to pay all costs, and the court disapproves the defendant's placement in any program of shock incarceration, intensive prison program, or transfer to transitional control. Mr. O'Connor, is there anything else for the record at this time?
Nothing else, Your Honor.
today in the state of Ohio versus Amanda DeWitt, case number 23 CR 001098. Defendant is present at open court today with her counsel Brett Urankar. Your Honor, we're here today for a change of plea. On October 17th of 2023, a two-count indictment was filed, count one being aggravated trafficking in drugs with only the fourth degree with a forfeiture specification, and count two being aggravated possession of drugs with only the fifth degree with a forfeiture specification. The state's understanding today that the defendant will withdraw her plea of not guilty and enter a plea of guilty to count two, aggravated possession of drugs, the felony 5 with a forfeiture specification. Count one would be dismissed at the time of sentencing. We'd ask to defer sentencing for a pre-sentence report and drug and alcohol evaluation. There's no sentencing agreement, and that's the state's understanding at this time.
Thank you. Mr. Urankar, is that not accurate?
That is accurate, yes.
And Ms. DeWitt, were you able to hear what the prosecutor had to say regarding what she believes your plans are here this afternoon?
Yes, sir.
She indicated to the court she believes that your desire to withdraw your previous entered plea of not guilty to count two and plead guilty to that charge. Count one would then get dismissed pursuant to the agreement. We would then defer sentencing to get some reports completed, come back on a future day for the sentencing hearing where there's no agreement between the parties regarding any recommendations. Each side's free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
Yes, sir.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you can ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Okay.
All right. Well, let's get started then. How old are you?
I'm 45.
Are you able to read and write the English language?
Yes, I am.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes.
Now, before coming into court here today, have you any drugs or alcohol of any kind?
Have I?
Yeah.
No, sir.
What about within the last 48 hours?
No, sir. I'm in treatment.
Well, that's never stopped anyone before.
Oh, no,
But,
sir.
all right. What about prescribed medication, anything?
I take prescription medication.
Okay. What prescription medication would you have had within the last 48 hours?
I take a Boost Bar,
Okay.
Abilify.
Hang on. Buspar, Abilify, gabapentin.
And I'm on another medication. I'm not quite sure the name of it because they just switched me. So
What's it for?
it's for my HIV. I'm undetected, so it's.
Okay.
I'm getting ready to take injections. So, however, so.
The whole reason I'm
Yeah.
I'm only concerned with, I want to make sure you're of clear mind right now.
Yeah,
That's the only
but
reason
I'm
I'm
just letting
asking.
you
So
know.
what's going to happen in the future is fine, but I'm just concerned about your state of mind right now. I want to make
Yeah.
sure you're not under the influence of anything, whether
Oh,
it's
no.
illegal or legal, prescribed, that's affecting your ability to understand or appreciate where you are, what's going on, anything like that.
No, I'm not.
Nothing? So you're not having any difficulty understanding me, communicating with your lawyer, no issues knowing where you are, anything like that because
Oh,
of the
no.
medication that you've taken?
No, sir.
Good. Now, you would have received a copy of the indictment in this case. You probably got it, like a month ago, about a month ago. You remember
I got it.
getting that?
Yes.
And,
How'd they arrested me and I received it there.
okay. In that indictment, you're charged with 2 counts. You're pleading guilty to one of those counts. In count 2, the charge you're pleading guilty to alleges on or about December 14th, 2022 in Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine, which is a Schedule II controlled substance. The amount involved did not equal or exceed the bulk amount. It was 1.89 grams, which makes the offense aggravated possession of drugs, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes, sir.
Any questions about that charge or what it is you're accused of doing?
No, sir.
Now, there is the first count of the indictment that's being dismissed pursuant to the agreement. Is that your understanding?
Yes, sir.
You have any questions about that charge?
Mm.
Well, then before I can accept your, well, let me go back up. I forgot to read to you the forfeiture specification. With count two, there's an additional forfeiture specification that alleges during the commission of the offense you possessed or had an interest in property that was considered to be contraband or an instrumentality. Contraband is property that's illegal to possess because the property is illegal, whereas instrumentality is some type of property. There may not be anything illegal about the property, but it's being used in an illegal manner and you can't possess it for that purpose. And here it's alleged is the methamphetamine itself along with some packaging. The whole point of that is you forfeit any right you had to that property at the time of sentencing. You understand that?
Forfeiting a property, what?
You're not,
The drugs.
forfeit any right you have to that,
Oh, yeah,
that
yeah,
property.
That's fine.
Okay, but just,
I don't even want that shit back, that's fine.
well, that's the point of it is, all right? They have to have a mechanism to be able to get rid of it, and that's how they get rid of it.
Okay,
Any
good.
questions about that?
No.
All right. All right, well then, before I can accept your plea, again, I need to make sure you understand everything going on, all the rights you're giving up. And you, first of all, have the right to have a trial in this case. Now, the trial could be to me as a judge, or I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would sit and listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, whether you were guilty or not guilty of the charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty to count two, you're giving up the right to have a trial regarding this count?
Yes, sir.
Now, if we did have a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Now, by her having the burden of proof, what that actually means, it's her job, or she bears the responsibility or the obligation, she bears the burden of proving you guilty before you could ever be found guilty. You're presumed innocent of these charges, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, I speak of the burden of proof since it's a criminal case that we have here. The burden of proof is what we refer to as proof beyond a reasonable doubt, which is the highest burden we have in our justice system. And what it actually means, it's the amount of the evidence and the quality of the evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty. Do you understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to try to do that, if we were going to have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. He could ask them anything he wanted to, within certain rules. You understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come into court and testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that, but you have the right to do that if you want. Do you understand that?
Yes, sir.
And you further can request the court issue an order, and we call that order a subpoena. And what a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
And do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that's above me. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding that I will make if I accept your plea, as well as any other issues you could raise or challenge up to this point. Do you understand that?
Yes, sir.
All right, well, do you have any questions about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
You understand your guilty plea will be a complete admission of guilt, so you'll be admitting to the facts being alleged by the prosecutor regarding count 2. We're not gonna argue that you didn't do it, or it's someone else's fault, or anything like that. Do you understand that?
Oh, yes, sir. Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you'll subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty here to a felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, sir.
Now, do you have any other charges pending against you right now?
No, sir.
Are you on, or were you on probation or post-release control when this happened?
No.
You weren't on post-release control?
No. I think I was off, but I'm not quite sure. I'm off now.
Well, that doesn't matter. Well, I don't know. If she's off now, then it does matter.
There is case law that says if you were on at the time, it still can be used at the time of sentencing, even if you were off. She was on post-release
Well,
control.
how much would I have left?
The year.
Well, okay. If you were on post-release, let me advise you why I'm asking. If you're on post-release control at the time you commit a new felony, the judge who is sentencing you on the new felony, which would be me in this case, has the right, whether I was the judge in the original case, which I think I probably was.
Yes, you are.
But even if I wasn't, I would have the right to terminate your post-release control and impose a prison term of the amount of time you have left, or 12 months, whichever is greater. Now, you don't have any time left.
I really think I was off, though. I really think I was off.
Well, then,
We'll take a look
we'll find, we'll know.
He's gonna
I'm just
revise
telling, if you were on, this is what, it's not mandatory, I don't have to do this,
Right.
but I have the discretion to do this. Let me finish it, so I make sure I advise everything.
Okay.
If you were on post-release control when it happened, I could sentence you to an additional 12 months, or the amount of time you have left on post-release control, whichever is greater. Now, if it's done, then the most I can give you is an additional 12 months. It's not mandatory, it's not required, but I could do that. Do you understand that?
Yes.
And if I were to do that, any time I would do for that would have to be consecutive to any sentence given to you on the underlying charge. You understand that?
Yes, sir.
Okay. And we'll find out then if you were or not during the pre-sentence phase. If you weren't, then that's irrelevant. If you were, then that's a possibility. It's not mandatory. Any questions about that?
No, sir.
If a prison sentence is imposed in this case upon your release from prison, you could be placed on post-release control for this case. It's not mandatory. It could be up to 2 years, though. It's up to the parole authority to decide that. Do you understand that?
Yes, sir.
And if you are put on post-release control and ever violate any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50%, or half of the prison term imposed by the court. Do you understand that?
Yes, sir.
Now, aside from the possible prison terms I just mentioned, there's other sanctions that could be ordered. You could be fined up to $2,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, sir.
I also have the discretion to suspend your driver's license for up to 5 years. It's not mandatory, but I could do that. Do you understand that?
Yes, sir.
And as I alluded to before regarding that forfeiture specification, any right, title, or interest you have to that property will be forfeited to the state of Ohio. Do you understand that?
Yes.
All right, a few moments ago, I explained the possible prison sentence. I did use the word possible. Prison is not mandatory in this case or required. Excuse me. You are eligible for probation, or what is referred to as community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you will be put on probation automatically? It means I'll consider that if that's what you're going to be asking for. I'm going to look at all the information presented, and I'll make the decision I think is the right thing to do. Do you understand that?
Yes, sir.
Now, if you are put on probation, it could be up to 5 years of supervision. As a judge, I do have the discretion to order a wide variety of rules and conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, sir.
Further, if you were put on probation and you ever violated the conditions of your probation, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, including local jail time, or I could terminate your probation and send you to prison. If I did it at that point, again, it could be 6 to 12 months in prison. You understand that?
Yes, sir.
Lastly, when we do come back here for sentencing, you'll have the right at that time to say anything you want. Anything you want me to know or consider, your lawyer could speak on your behalf, he can recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, excuse me, it is just what it says, a recommendation. I don't have to follow it if I don't think it's the right thing to do.
I'm well aware of that, sir.
Okay. All right, do you have any questions for me, Ms. DeWitt, regarding anything we've just talked about regarding the potential penalties you face?
No, sir.
Understand all the possible consequences?
I do.
And you still want to plead guilty?
I do.
Have you had enough time to talk about the case with your attorney and have him go over everything with you and answer your questions?
Yes, I've called him, I've talked to him several times on the phone, so yes,
Are
sir.
you satisfied with his advice and counsel?
I am.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No,
Have you been threatened or coerced in any way to plead guilty?
no,
Are you entering your plea freely and voluntarily?
I am.
All right, any questions for me at this time regarding anything we've just talked about?
No. I just want to apologize for having to come back in front of you again.
You'll get a chance to do that at sentencing.
I know. I just wanted to say that again.
Do you need any more time to speak with Mr. Uranka before we go forward with your actual plea?
No.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I need you to listen to her, because I'll have some questions for you about that, all right? Scott.
Thank you, Your Honor. Excuse me. If this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on December 14th of 2022, Lake County Narcotics Agency was working with a confidential informant, CI 1380, who was familiar with the defendant Amanda DeWitt for possessing methamphetamine in Lake County, Ohio. The CI was able to confirm Amanda DeWitt's identity through photograph. Initially, the confidential informant was in contact with the defendant to meet up at 2250 North Ridge Road, number 7 in Lake County, Ohio.
Let's just talk about the possession. That's all that she's pleading to.
Right, but I have to get her there.
Well, we don't need to go through all this.
On December 14th of 2022, the CI went and met with Amanda DeWitt at 2250 North Ridge Road, number 7 in Lake County, Ohio. At that time, Ms. DeWitt had methamphetamine at her location. She was seen weighing it, handed a portion to the confidential informant. That substance was later provided back to Lake County Narcotics Agency, who sent it on to the Lake County Crime Lab. It was found to be 1.89 grams of methamphetamine, a Schedule II controlled substance that had been in Ms. DeWitt's possession. And that's the evidence the state would have provided.
Thank you. Ms. DeWitt, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, sir.
And what, if anything, you have to say about those facts as she presented them?
It's true.
All right. That was my question. Are they true? You do what you said?
That's true.
Very well, then, regarding count 2, charging with aggravated possession of drugs, a felony of the 5th degree with the forfeiture specification, what is your plea to that?
Guilty.
All right, I have in my possession at this time a document called a written plea of guilty and judgment entry, which explains everything we've just talked about. Before I can accept your plea, I need to make sure you understand what's in this document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over this with your lawyer. Is that correct?
Yes, sir.
Mr. Uranka, is that accurate? Did you read this to your client and review it with her?
That's accurate.
Did she, in doing so, indicate an understanding of it to you?
She did indicate an understanding.
Is that correct, Ms. DeWitt?
That's correct.
Any questions for me about what the document says?
No, sir.
Now, it appears that you signed the document. Did you in fact sign it?
Yes, sir.
And Mr. Uranka, did you witness that?
I did.
And Ms. Kutcher as well?
Yes, Your Honor.
Thank you. Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer. She was advised of all her constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant does understand the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding it all to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 2, aggravated possession of drugs, a felony of the 5th degree in violation of 292511 of the revised code with the forfeiture specification. count one will get dismissed at sentencing, but I'm gonna defer sentencing, order a pre-sentence report investigation, drug and alcohol evaluation, and I'll continue bond at your own recognizance. Is there any conditions with that bond?
Only condition is no use of drug or alcohol.
Okay, that's all, okay, thank you. So what all that means, Mr. DeWitt, as far as your bond goes, I've continued that, you've already posted it by signing. There's nothing more you need to do except to continue complying with the conditions, which one of them is that you don't use any drugs while you're on bond. You'll have to submit urine screens if requested, they have to be negative. A positive screen will result in your bond being revoked and a warrant being issued for your arrest.
I do have one question for you. I do have a medical marijuana card, however, I have not been smoking no marijuana. So my question is, am I allowed to use the card?
No.
Okay, so just continue doing no drugs,
Continue what?
using no drugs,
Correct.
okay.
Okay.
All right, I just wanted to make that
Okay,
clear.
that's fine.
Okay.
Glad you did. All right, so you're gonna leave here now, you're gonna go to the probation department, meet up with them to fill out some initial paperwork and get the dates to come back for your interview. Now, this interview is important because that's how probation department gets the information they need to prepare the report. So it's important that you're open and honest with them when you answer their questions, because they're gonna let me know everything you tell them. And if you're misleading them in any way, they're obviously will let me know and I'll consider that. Also, this pre-sentence report has to be completed for you even to be eligible for probation. Without a pre-sentence report, the law does not allow me to consider probation as an option. And in order for that report to get completed, the interview with you has to take place. So it's important you show up on time when scheduled for the interview. Because if they can't conduct the interview with you because of your lack of, cooperating or not showing up, then they can't complete a report. Without a report, I can't consider probation, and I won't continue the sentencing to another day to get the report done because you didn't show up initially when you should have. Understand that?
Yes, sir.
All right. Ms. Cutts, anything else for the record?
No, thank you, Your Honor.
Mr. Urankar.